Hello and welcome to this short podcast, which is intended to be an update on trade negotiations happening between the UK and the European Union, and to consider the impact of European Union law during the transition period. It's recorded in March 2020 by me, Ryan, and so let's make a start. So thinking first about the trade negotiations before we go on to any level of detail, just wanted to outline broadly where we are, where we're up to at the moment, and where we might be going with the trade negotiations. So the UK did leave the European Union on the 31st of January 2020, and in practical terms this meant that the UK ceases to be a member state of the European Union, ending the more than 40-year relationship of membership that the UK has had. And quite crucially, the UK left all of the European institutions. Now, for some people, you may be wondering, well, how can the EU law continue to have an impact on the English legal system if the UK is no longer a member of the European Union? And that's because the UK and the EU recognise the difficulties that would be caused by the UK's membership ending in an abrupt manner, in the so-called cliff edge. And so the UK and the EU have entered into a transition arrangement that is due to last until the 31st of September 2020. So essentially, what the UK and the EU have decided to do is to preserve aspects of their relationship until the 31st of December 2020. And during this time, although the European Communities Act 1972 was repealed, it continues to have effect. This is a slightly novel solution to the problems caused by transition. And essentially what it will mean is that European Union law will continue to have effect in the UK during that period. If this transition period is to be extended, then both sides would need to agree to that by the 30th of June. And actually up until much earlier this month, which is currently March 2020, the UK government has been adamant that it wouldn't extend that transition period under any circumstances. So even if a trade deal were not in place by the 31st of December 2020, the UK government maintains the position that it will not extend. Now, things have changed, the facts have changed slightly, the context has changed slightly in the fact that as of March 2020, the UK and indeed the rest of the world is suffering from an outbreak of a virus, COVID-19, and this has essentially halted or postponed face-to-face negotiations between the EU and the UK. And both the EU member states and the UK are currently trying to deal with the very significant impacts of that virus, including shutting of schools, the closing of all but essential services, the impact on the health service. All of those things mean that there is a possibility that the UK government's position will change as it becomes apparent that negotiating a trade deal at this time will be very, very, very difficult for both sides. The intention of the transition period is to prepare the way for the new world where the UK has a very different relationship with the European Union. So in essence, it will allow the UK government and the UK Parliament to tidy up the statute book, to identify all of the anomalies that will be caused, all of the difficulties that will be caused, all of the problems that will be caused by the UK leaving the European Union, and to resolve those. And also, and crucially, the purposes of this discussion, it was to allow the UK to reach a trade agreement with the EU. So the so-called no-deal prospect of the UK and the EU trading on WTO terms is still very, very real. And the one-year transition period was intended for both sides to negotiate a comprehensive free trade agreement. Now, whether it's possible to negotiate a comprehensive free trade agreement within a year has been subject to much discussion. It's not the purpose of this short podcast request to revisit those discussions, but just be aware that there is some debate about the extent to which you can achieve and implement a trade deal in that time. One of the consequences of, one of the other things we need to bear in mind, particularly in terms of secondary legislation and some of the things that are discussed in the chapter on secondary legislation within the textbook, is that the UK leaving the EU has the potential to cause so much disruption to the statute book that the government has given to itself, or Parliament has given to the government in the form of the Withdrawal Act, a number of Henry powers. So these are powers that allow ministers to amend primary legislation. These are very, very strong powers, and the UK government intends on making full use of those powers in achieving its end of tidying up the statute book. So let's consider briefly the position of EU law post-Brexit. So during the transition period, as I've mentioned previously, things roll on as normal. EU law applies as if the UK was still a member state. So the UK is still subject to enforcement action by the Commission. The UK can still be brought before the European Court of Justice during this position, and any EU law passed during this time will, through the European Communities Act, become enforceable within the UK if it's directly applicable, or will potentially require transposition into domestic law. So, although things roll on the same, as I say, the government has been given very significant powers through Henry VIII, powers in the Withdrawal Act to allow for changes to the statute book. And there is even, there are new parliamentary procedures that have been put in place, sifting procedure and all that sort of stuff, which is mentioned in the textbook and which will allow the UK government to change UK law to accommodate our exit from the European Union. So that's during the transition period. What about after the transition period? Well, after the transition period, the provisions of the European Union Withdrawal Act 2018 sort of kick in, and a large portion of EU law, of what's traditionally been EU law, will become part of domestic law as so-called retained EU law. So it's not the case that the link is completely severed between European law and domestic English law once the transition period is ended. Instead, because of the number of gaps, the amount of legislation, the amount of legal provisions, rights, obligations, etc., that have stemmed from our membership of the European Union, it wouldn't be possible to replace all of those in time for the end of the transition period. And so that law will become so-called retained EU law. In essence, what happens is a very large bulk of what is existing EU law becomes English law as a result of the provisions of the European Union Withdrawal Act. There are a number of different forms of retained EU law, and many of them are discussed in the European Union chapter of the textbook. So there's EU-derived domestic law. These are things that have their origins in the European Union and in European Union law, but which have been somehow implemented already or incorporated through the European Communities Act into domestic law. So, to give an example, the Working Time Directive is EU law directive passed by the European Union, and because it's a directive that required implementation, it was implemented into English law in the form of the Working Time Regulations, a piece of secondary legislation. And what the European Union Withdrawal Act does with this form of EU-derived domestic law is that it automatically makes it part of English law. The effect of the Working Time Regulations will continue even though the parent act, the European Communities Act, will have been repealed. And so there's direct EU legislation. Direct EU legislation is legislation that was directly applicable in the UK already in the English legal system without the need for further implementation. So this would cover things like EU regulations, which didn't actually need to be implemented. They automatically became part of domestic law via the European Communities Act. Once that link has been severed, so once the European Communities Act ceases to have effect at the end of the transition period, then the EU Withdrawal Act domesticates, makes part of our domestic legal order those rules contained currently within direct EU legislation. And then there is this sort of catch-all of all other rights, powers, liabilities, obligations, restrictions, remedies, and procedures. So this is lots and lots of EU law that doesn't fall within the category of EU-derived domestic law or direct EU legislation will still become part of the English legal system. And this covers lots of what were formerly called directly effective rights in EU law. And then of particular interest to those who are studying the court structure, what happens to all of those thousands of cases of the European Court of Justice, which were part of the jurisprudence of the CJEU, what happens to those? Well, cases before exit day, so cases passed before exit day, so before the end of the transition period, are binding. So these are binding on all levels of our judiciary. They must follow them as binding precedents. The CF, the sort of noted caution I would add, is that the Supreme Court will be bound by CJEU judgments that were passed before exit day in the same way that they're bound by their own judgments. In other words, the Practice Direction of 1966, which allows the Supreme Court to overrule its own judgments, will now apply to cases of the CJEU. So the Supreme Court will be able to overrule and it essentially not be bound by prior judgments of the Court of Justice passed before exit day, given before exit day, on the same basis that they can currently depart from their own judgments. Cases after exit day, much more straightforward. Courts will take account of these judgments, but will not formally be bound by those judgments. And therefore, cases from the European Court of Justice will become persuasive only if those cases are passed after the end of the if judgment is given after the end of the transition period. So let's turn our attention then from the effect of EU law to the trade negotiations and what's likely to unfold over the coming months. Well, the first thing to say is that February, March time, the EU published its negotiating mandate, and that mandate is proposed under Article 218 and will be adopted, has been adopted by the Council. This is quite telling from the outset about the nature of the European Union, how it differs from, as a legal system, from the English legal system. That's because, as you'll remember from the textbook, the European Union is a body of conferred competence. It can only do the things the treaty allows it to do, and it's hedged in by the processes of the treaty. And so the treaty lays down the rules on how the EU makes rules. And this is very, very different to the English legal system, where you have original sovereignty, you have parliamentary sovereignty, Parliament can do what it wants unconstrained. And so what we see is the EU's negotiating mandate has now been agreed, and this will form the basis of the negotiation with the UK, and the EU negotiators will have only a narrow margin of discretion in deviating from the agreed negotiating mandate. So the EU from the outset is aiming for a sort of association agreement that needs to be ratified by the Council and with the consent of the European Parliament. If whatever agreement or agreements, trade agreements, come up with the UK are classed as mixed agreements, and there's some discussion about whether that applies to fishing, then there's a potential role for national parliaments. And what you have to think is, if the trade negotiations are to be advanced and complex negotiations covering a comprehensive free trade agreement, then there is this outside chance, or this chance, that all national parliaments of the EU member states would need to be consulted. Why does this matter? Because it really puts in question whether it is possible to achieve a deep, meaningful new relationship with the EU in the timescale between the transition period starting in January 2020 and ending in December 2020, essentially giving you 1 year to conclude the agreement. The EU's main conditions or positions, and we'll compare these in a moment with the UK's, no tariffs or quotas, so that's fairly basic free movement of goods type trade rules. The possibility of anti-dumping and anti-subsidy rules, so the EU already has these for third countries, and if it's felt that there's a chance that the UK will dump cheap goods on the EU market, I think that's rather unlikely, but there we go. Then there might be subsidies placed on those goods, there might be duties placed on those goods, and then more importantly, if the UK moves to a situation of subsidising certain industries, then the goods that those industries produce may be subject to anti-subsidy duties. The big bone of contention, as we'll see, is that the EU is quite keen on a level playing field, and level playing field essentially means common rules. And the UK's position, the EU's position as it's evolved, makes clear that those would be EU-based rules on certain taxes, on state aid, the support that governments give to certain industries and certain companies, competition law, and certain work and environmental standards. So this level playing field is to stop the UK taking advantage of the benefits of the EU's internal markets, but also making itself a competitive, an overly competitive player in terms of tax, state aid and competition. So they're saying, you must adopt, we must agree to these common rules to which you will abide, otherwise we're not going to give you full access to the market. And fishing is a massive issue for certain EU member states, and they want to have a separate agreement resolved, or the fishing question to be resolved, hopefully by July, because that looks like it might be one of the sticking points, which is slightly odd because the UK fishing industry is not a major contributor to GDP, although in certain rural locations it is an important industry. It's no bigger than, for example, the video games industry in the UK. And so the point about fishing, I guess, is that there is something that speaks to sovereignty. There is something about having control over your waters, over your fishing waters, that chimes with this mantra of take back control. So how does this negotiating position of the EU compare with and contrast with the UK's negotiating position? And you'll notice that on this slide it uses the word the EU's negotiating mandate, and on this slide it uses the word the UK's negotiating position. This is because of the difference I pointed out earlier. The English legal system, or more broadly speaking, the UK, it is not bound by that principle of conferred competence. The UK government can negotiate whatever it wants, and Parliament can agree to whatever it wants. The UK is absolutely adamant, or has been absolutely adamant, that it won't extend the transition period. This was a key plank of Boris Johnson's Conservative government's, Conservative Party's manifesto in the late 2019 election, because that's when we moved to, was that we get Brexit done, we don't extend, no more dither and delay was one of the mantras that was spoken. So the UK's position currently, that may change as a result of the global pandemic outbreak of COVID-19 coronavirus, but the UK is currently adamant that it won't extend that transition period. The UK is saying that it wants a broad outline, although what exactly a broad outline is, it's not made clear, of a deal by the summer. So it wants a deal by, a broad outline of a deal by the end of the summer, or they will walk away from further negotiations and focus on no deal preparation. Essentially, they will turn all of the machinery, all of the resources of government towards preparing for a no deal situation. that the UK has already started to walk away from certain agreements. Most recently, when this recording was made in March 2020, the UK walked away from the European arrest warrant system, which was perhaps unsurprising, perhaps surprising, depending on where you thought the negotiations were going to go. The UK is very keen that it wants a Canada-style free trade agreement. So it wants a fairly liberal trade agreement, but with no alignment of common rules. And the EU current position is, well, you're not Canada, and therefore you can't have a Canadian-style free trade agreement. But the geography of Canada, that the market relationship with Canada is very different, and the UK is starting from a very different place than Canada started, and therefore the outcome is going to be very, very different. And so you can see this sort of, the tussle has already started between what sort of agreement the sides are going for. The UK will want access for financial services, huge industry in the UK, and one of the big pieces of leverage that the EU currently has over the UK is in relation to financial services. That the government has talked about, well, if everything else goes wrong, we can have an Australia-style deal with the EU. And essentially what that means is no deal. It's another way of saying no deal. It's a way of avoiding saying that there will not be a comprehensive free trade agreement, because the EU currently doesn't have a comprehensive free trade agreement with Australia. And so you can see sort of the rhetoric of the negotiations sort of ramping up even from the outset. That the UK has made very, very clear that it will not accept the European rules on state aid, European rules on competition law, European rules on tax, and therefore the UK is rejecting one of the key planks of the EU's negotiating mandate, and that is the level playing field. The UK is saying we will not accept a level playing field. And so we shall have to see how this pans out, and whether this is likely to be one of the major stumbling blocks in terms of the future negotiations. Ireland, in the UK's negotiating position, which was published in February, March 2020, Ireland features very, very little. Surprisingly little is said about the arrangements for the ongoing arrangements for Ireland. In fact, it's mentioned, I think, fewer than 10 times in the document. And that's slightly surprising, but Ireland will continue to be one of those thorny issues that needs to be resolved in order for a full free trade agreement to be agreed. Fish, so the EU has recognised and wants to go for this deal by July. The UK has said, we will negotiate with fish, but it's not going to be anything like the current relationship we have now, where essentially you have long-term agreed quotas, and Spanish fishermen and Norwegian fishermen and whoever can come into British waters and fish their quota there. What the UK wants to move is to an annual negotiation on access. So not an open-ended deal on fish, but in fact they want an annual negotiation on access, on the split of quotas, those sorts of things. And that will be very, very challenging for the EU and would give the UK an amount of leverage. One of the issues that the UK faces is if the negotiations don't go terribly well, then most fish caught in British waters, whether they're by British fishermen, whether by Spanish fishermen, by whoever, is that those go back to the European Union. So most of those fish are not consumed, sold, and marketed in the UK. And the risk is that if the trade negotiations on fish don't go well, there is a risk that the EU retaliates with quotas on fish and with duties on fish, customs duties on fish, and that would be very problematic for the UK fishing industry. And so you have this sort of complex levels of leverage that change depending on the final agreement of who holds the balance of power. That the UK says that it has one of the strongest worker protection regimes in the world and doesn't really need to abide by EU rules on workers anymore, because the levels of protection in the UK are higher than those elsewhere in Europe on certain matters. And so the UK is not really wanting to negotiate a a matching position and a full alignment with EU rules on workers. The UK also wants no agricultural safeguards on foods, so on goods, particularly agricultural goods like livestock, or on agricultural goods like meat. And this is where you see the real complexities of the choices that the UK has to make. So the EU would be happy to go along with reduced or no agricultural safeguards on goods, provided the UK abides by existing EU standards on food and on welfare of animals. And this causes huge problems for the UK, because the UK doesn't just want to negotiate a full free trade agreement with the EU. It also wants to negotiate a full free trade agreement with America, with the United States of America. And this is where you may have heard of all of the fuss around chlorinated chicken comes from. And that's because chlorinated chicken, bathing chicken carcasses in a chlorine wash to get rid of all the germs and the bacteria, is outlawed. It's unlawful in the EU because it normally has lower welfare standards than meat would have had lower welfare standards through the whole of the supply chain. And so if the UK wants a fundamental trade, it wants to achieve its negotiating position here of no agricultural safeguards on food, then it must maintain, it must align with EU welfare and agricultural product standards. If it wants a trade deal with the US, then actually all of those things still need to be up for debate. The UK cannot, or would find it very difficult to walk into the trade negotiations with the US on a wide-ranging free trade agreement if it said, actually, we can't discuss agricultural products. We can't discuss it because your welfare standards, your food safety standards are not aligned with the EU's. And if we lower our standards, we lose access to the European market. But we gain access to the American market. And so this is where we come to this idea of choice. The UK has some hard choices, and indeed the European Union has some hard choices about which of these things listed are actual hard red lines, and which will, over time, be subject to reading down or backing away from. And that sort of completes a very brief sketch of the negotiating position in March 2020 of the trade negotiations between the European Union and the Free Trade Agreement. Please check back on the website because more podcasts will, I'm sure, be following.